Hey guys, welcome back to Kitchen Court Cases, where we watch court in my kitchen. We're back in Judge Izelo's court in Texas on that civil docket. Let's check out what she's got.
All right.
Hello, Judge.
Hello. Back for the last case of the day. I'm gonna get my eyes on it. Hang on one second here. Okay, so we're here now on D-1 GN 21-000142. This is Ricky Rogers versus Federal Express and Telus Smith. We're here on a motion to compel. May I have announcements for the movement, please?
Yes, Eric Cuellar for the plaintiff, Ricky Rogers.
Okay, and for the plaintiff. All right, may I have announcements for the defendant?
Ethan Glenn for defendant Telus Smith and Federal Express Corporation.
All right, very good. Now, you all have not requested a record, is that correct?
That's correct.
That's correct, Your Honor.
Very good. All right. So I looked a little bit at this motion. I have to admit, when I first reviewed it today, I thought, wow, I can't get my arms around this one. So I take it you all have had some good discussions and have actually narrowed it down. So rather than go back, that's great. Rather than me go back and pull it up and start reading into it again, let's just hear what you have. So maybe we can really focus the court's time today and figure out, get y'all a decision. All right, who would like to proceed? Whose motion to compel is it, I guess is the first thing.
It's our motion to compel, Your Honor. I can proceed, Your Honor.
Please do, yes.
Yes, well, we've agreed on many of these topics. We're just left with two, number 10 and number 16. Number 10 is prior incidents, complaints, disciplinary actions, and collisions involving Telus Smith, who is the driver of the FedEx van, and prior collisions by drivers working for FedEx Corporation. And we're agreed on the first part, Your Honor, about prior incidents involving the driver himself, but we're in disagreement over prior collisions by drivers working for FedEx. And I think this has become relevant because in Telus Smith's deposition, Your Honor, he testified that he had been working a second job while driving for FedEx and had actually been working that second job the night before. And he was working 11 p.m. to 7 a.m. at a hotel. And then he went to work at FedEx at 10:30 a.m. So just 3.5 hours in between. You can figure, obviously, with driving back and forth to home, he wasn't sleeping more than 2 hours. And he said that he would do this often and that his supervisors knew about it. So we've alleged gross negligence on the part of FedEx because they had a driver who was working an overnight shift and likely driving sleep deprived for a long time or fatigued, driving on 1 or 2 hours worth of sleep. So that's where this comes from, where we're wanting to ask the corporate representative about prior collisions. It's not obviously about, prior collisions across the whole country. It would be prior collisions, related to sleep deprivation or employees that are working multiple jobs, if they even have that. And I understand they might not.
They might not.
They might not, but I think we'd like to ask to see if they know about that. If they know this is happening and they're just letting it happen, it's obviously, I think, a big problem with how many FedEx drivers there are. But, we've offered to maybe limit it to Travis County or something like that to limit the scope.
I understand. All right, let me hear from Mr. Glenn on his response.
Thank you, Judge. Yeah, so this is a commercial motor vehicle accident involving one of the courier vans that you likely see driving around Austin. So we're not talking about a big 18-wheeler. We're talking about a small van here. In terms of the discovery, yes, anything related to Mr. Smith is fine. When it comes to other drivers, Mr. Cuellar just talked about how, he wants to limit it to sleep deprivation, limit it to Travis County. It's not what the topic says. As the topic is currently constructed, it does apply to drivers all across the nation for any sort of wreck involving any sort of accident. So just first off, way overbroad. and very much not relevant. But even diving into specifics on if we were to limit this to just Travis County or just sleep deprivation, I think NRA UPS ground freight, which came out of the Texas Supreme Court just last year, is pretty on point on this. When it comes to the actions of other employees, even at the same station, that's not relevant and that's not discoverable. That's just simply a fishing expedition that is not going to be able to be used here.
I have to look at that case because I think it's relevant. I think it's relevant. If it's not, I agree with you 100%. Too broad, all of the United States. You cannot get to that. It's too much. But limited to Travis County, and those vans can do, I mean, I agree, they're not the big 18-wheelers, but they can still do damage. They're still a big van and they're still moving through our neighborhoods. And so, I mean, I think, I just don't see how you can say it's not discoverable. It might be not admissible, but not discoverable. Is that what that case is? If I go look it up, is it going to say that?
Yes, Judge. So I'll give you a little bit of background. So actually very similar commercial motor vehicle accident case where the plaintiff asked for the drug test results of the driver in question and the drug test results for all drivers at the same station. And that's it, which is pretty limited in scope compared to what we've got here. And the Texas Supreme Court said, no, that is not allowed. The production of test results, even from other drivers of the same station, is an impermissible discovery request. Yes.
But drug test results are different. We're not talking drug test results here. We're talking people working second jobs, I guess, or accidents. What, Mr. Cuellar, tell me, I thought the language you gave me sounded more narrow. What was that, Mr. Cuellar?
Related to sleep deprivation, or drivers having multiple jobs or second jobs.
Right.
Just those two things.
All right. So we're talking accidents in Travis County committed by drivers who have second jobs or where sleep deprivation has been a factor in the accident. Is that what you're saying?
Yes, Your Honor. Yes, Your Honor. As far as sleep deprivation, we've alleged sleep deprivation / fatigue. But so I would say those two parts of it, Your Honor.
Mr. Glenn, that seems pretty reasonable to me. You think that Supreme Court case is when it's not a drug test?
I think yes, we're talking about collisions v. drug tests, but the point was the same. They're saying, okay, well, if this one driver had a drug test result that was bad, let's go find all the other ones. And that's exactly what's happened here. Is Mr. Smith has an accident, let's go find all the other accidents. And even if it's just limited to that station, it's not relevant, it's not admissible, it's an information.
But it is relevant. It is relevant. And that's the issue here. It is relevant. Because if you've got a station where someone is not, you've got a supervisor who's allowing people to drive. Now you may not. This may be a one-off. And who knows, it very well may be a one-off. One person, it's a different story. But if you have an accident, you have an accident of a station where a manager or supervisor is turning a blind eye to people working very long hours at second jobs and being too tired to safely operate their Federal Express truck, I think that is relevant. So I'm having a hard time with that Supreme Court case. So I'm going to think on that for just a minute. What's the second one? It sounds like y'all have done a lot of good work, though. I do appreciate that.
Judge, before we get into that second one, I did want to bring up, and this doesn't really go to whether or not you say yes or no, but just to that first one, on a practical note, I wanted Mr. Cuellar and the court to be aware that if the court does grant that limited to Travis County and sleep deprivation or second jobs, I am not entirely confident that there will be anything responsive to that, because as far as I'm aware, that's not how we classify things. So I just wanted that to be clear.
No, I understand that too. And I think that sometimes gets into kind of an affidavit of no record, or at least he gets to ask questions about it. Maybe they know, maybe they don't know. But it's not there's no reassurance. There will be information along those lines, but you can see, at least I can, from the perspective of plaintiff here, why that type of information would be relevant. If there's a problem with sleep deprived drivers or folks working very long hours going out, that's, I think, is relevant. So I get you what you're saying. Hey, there may not be any responsive information. But I think he does get to inquire about that. So, all right. But I hear where you're coming from, Mr. Glenn. Absolutely. That may not be. And we just don't know yet because the discovery hadn't been done yet. But all right. Y'all have done some good work though, as I say. Tell me what your second one is. What's the second issue here?
That's number 16, Your Honor. It's about the driver's work schedule, miles traveled, hours logged, his driving record and history before and after the incident. We pretty much agreed on a lot of that, Your Honor.
Okay.
And tried to maybe narrow the scope of the time. However, I would like to be able to ask about incidents and miles traveled and hours logged, with a broader range than say a month before or 2 weeks after, if it's related to sleep deprivation or if it's related to his second job, or if he got into an incident or a crash or had a disciplinary action. I'd like to be able to ask, about his hours on that day to see if it's related to his other job or him being sleep deprived.
So what are you wanting to do, Mr. Quay? Are you wanting to have, it's the request, and I'm sorry, I don't have it in front of me. You can see we've got very glitchy internet today. So I do not want to move from the screen because I might not be able to come back. Are you wanting a broader scope on this question?
I'm trying to limit it because as it is right now, it's his entire work schedule, but obviously we're agreeing to try to limit this, and we worked with Mr. Glenn to try to limit it. I think he was proposing a few weeks before and a few weeks after. So I think my proposal would be 1 month before and 2 weeks after, and anything else related to his hours and work schedule, if it has anything to do with a traffic ticket or a disciplinary action at FedEx. I think that might resolve the problem.
What do you think about that, Mr. Glenn?
I think that limiting the scope is the entire issue here. We had proposed 2 weeks, and until 30 seconds ago had not heard a response. I think 1 month before is reasonable and a perfect way to split the baby. I do think after the accident, it's just not relevant at all and never will be. So I would object to anything after the accident, but I think a 1 month before would be fine when it comes to the work schedule and hours logged.
Mr. Quayer, that sounds pretty good to me. The after, I agree, is a little bit weird, but the before, the 1 month before, is that going to get what you need?
Yes, Your Honor. And if I can understand Mr. Glenn, I think he's just talking about the work schedules, but obviously I think if there's disciplinary actions after, then that's relevant, but I don't know if he's referring to that.
Okay. What about the after? What's the issue with that? Is there still something that's not clear on this question, gentlemen?
I've just taken the position, Your Honor, that anything after the accident, whether disciplinary or not, is not relevant. We are focusing on the work schedule and the hours logged because that was the only scope that we needed when it came to his driving record and to his driving history before the incident, which extends for years. I do agree that that's relevant and that we'd be able and willing to talk about that. We don't need a scope for reprimands or tickets or other accidents because that would obviously be relevant. Okay.
So I hear what you're saying about after, especially, kind of subsequent issues. But if this accident happens, if there's any disciplinary pertaining to him, that would, by its very nature, be after the accident. Is that already? I assume that's not what we're talking about here, because I think he would be entitled to that, right?
Yes, Judge, I agree on that entirely. I guess this would just be any disciplinary issues or records arising out of events that occurred after the accident. So that would still protect him and allow him to get any disciplinary records that arose out of this accident.
All right, Mr. Quayer, what are your thoughts on that?
A little confused if Mr. Glenn is agreeing to after the accident, if we'd be able to ask about accidents and disciplinary actions or terminations. But I think that we should be allowed that information.
No, if it's not related to this incident, I don't think that it's relevant. But I think if it's reprimands, terminations that arose out of this incident, yes, of course. that would be relevant. But any other events, any other accidents, or anything else that occurred after the accident, I think is just out of bounds.
Mr. Quayer, hear your
I think
view.
yes, Your Honor, I think it is reasonably calculated to lead to admissible evidence because there could be, other incidents that he had where, the reports notate that they've had this problem with him before, or it also goes to, their investigation of this incident and if they terminated him or not, or if they had any reprimand for him or not. But I think if he's terminated later and gets some crashes later, I think that's absolutely relevant. It also goes to, their failure to terminate him, which we've alleged as well.
The failure to terminate. Yeah, no, I hear you. I think that's true. All right, well, here's the situation. When did this accident occur?
Let me see, Your
Do
Honor.
we know?
It was March 6, 2019.
Okay, March 6, 2019. Gosh, that's been a few years. So
Quite a scope, Your Honor.
yeah, it is. But for a driver, I mean, listen, I see I know these driving logs are kept. I've seen them. I don't think that's really to get his disciplinary action between 2019 and 2023. I don't think that's unreasonable. And before that too, you're just trying to get a picture of this individual. And I think that's reasonable. So here's what I'm going to order. The first one that we had here today on the, whatever you all said, the other accidents out of the same station that relate back to sleep deprivation, relate back to second jobs, or what, if FedEx has anything pertaining to Travis County on that, other drivers, I'm going to grant the motion to compel. Pertaining to the next question, and you all keep in mind, this motion looks pretty different than when I looked at it. So help me if I'm not ordering something correctly. Let me know, because you all have done a lot of good work. I'm trying to kind of, take what you said to me today. So that first part is compelled. The second one that they're after, which is, if I'm understanding correctly, it's accidents and or disciplinary actions that occurred after the accident. So this is 2019 accident by this driver. Is that right, Mr. Cuellar?
Yes, Your Honor.
I'm going to grant that compel as well. So those are the only two that are left. I know 2019 to 2003, it's a while, but it's not a super unreasonable scope, not with a big company like Federal Express. They'll be keeping very careful logs of his driving. And I do think it's relevant if to some degree, may not ultimately be discoverable at trial, but I do think it's relevant in terms of Mr. Cuellar's case. So those are my orders for today. I would like you all to draft an order and get it to me. Do you think you all think we have enough information here to do that? I'm not being facetious. I really just feel like you all presented me with a bunch of information. We honed it down. That was excellent. Thank you. And I feel like I'm trying to work with what you've given me, but I hope I've ruled broadly enough and you all have enough direction to get an order to me.
Yes, Judge, and just one clarification on that 16. So I understand the discipline and accidents after, but in terms of work schedule and hours logged, I believe we kind of all came to an agreement on that 1 month prior to the accident.
I think 1 month prior to the accident.
Okay.
And Mr. Cuellar, I mean, you're amenable to that, right? I mean, that seems.
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. Anything else that we need to talk about today? Are you
No,
all?
Your Honor.
Are you clear on what you need to do, Mr. Lynn and Mr. Cuellar? All right, gentlemen.
Yes,
I want to get that order drafted. I'll get it signed and get it back to you. I very much appreciate your professionalism working this out. I have to tell you, when I saw that today, I thought, oh no, we're going to be spending quite a bit of time on this. John, so much good work out. I'm very, very grateful for that. And
Judge, you're cutting out a little bit.
Both may be excused. Okay.
Thank you, Judge.
Yes, thank you, Judge.
Well, yet again, another interesting case in front of Judge Low. So that was a motion to compel in a civil hearing where it looks like FedEx and one of their drivers is being sued by somebody. And the question was about what kinds of records are they allowed to ask for. I really like Judge Iserloh. I love how she runs her court. I love how appreciative she is of all the people involved. And I love how encouraging she is to the lawyers to work things out together. I think that's important, and I think it helps the judicial process a lot. Anyways, guys, let me know what you thought about this case down below. I'll see if I can try and follow it. It's hard to keep up with all these different cases, but I will do my best. And please go ahead and subscribe to the channel if you're not already subscribed. I put out court pretty much every single day. All right, I'll talk to you next time. Bye.